Good afternoon, guys, and welcome to today's edition of The Law and You. I am your host, yours truly, Attorney Shellon Washington, licensed in the state of New York and in my home country, Guyana, and also licensed in Trinidad and Tobago. It is my pleasure to be here again this afternoon, bringing to you today's series, which is brought to you by my law firm, Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. Guys, just a reminder, I know I say this over and over on all my show, but we offer free consultation. So if you're in need of legal advice, you're experiencing a legal issue, and we can be of any assistance to you, give our office a call at 718-877-3100. And today, guys, we're going to talk about protecting your family assets. What are some of the ways you can protect your asset against lawsuits, against divorce, against anything that you could possibly think of that is an act other than an act of God? Obviously, there's no way to protect assets against an act of God, like a flood or hurricane or fire, except if you have an insurance policy protecting that asset against those things. But outside of acts of God, we're going to talk about ways that you can protect your asset to ensure that it passes to your other generations. And guys, it's really important that we focus on this. And, it's not a good thing to just think, okay, because you just have a house, and you say, okay, it's just a house, so there's no need to do anything to protect it. Even if the house has a mortgage left on it, the house has equity. Most real estate will appreciate in value, which means that the equity can only go up. So even if you're the owner of a house, and I know there's a lot of Caribbean people that own property in the United States, and they come and they work very hard and they purchase these properties and they just have them and they don't consider like what happens next to it. Guys, if you're here, if you're joining this live, I will encourage you to click the like button and to share. Don't forget to share so that those people who might be in need of this content, whoever is in need of it most, will be able to see and receive valuable information to help them to carve out their situation or to seek out the right help that they might need. Again, this program is, as always, brought to you by my law firm, Washington Law Firm, located at 455 Utica Avenue, Brooklyn, New York. Phone number is 718-877-3100. So, guys, let's get into it. So if you have an asset, stocks, bonds, cryptocurrency, all of these things that are considered asset, even money sitting in the bank is considered an asset, even jewelry. Some people choose to build wealth by purchasing expensive jewelry like gold or diamond, or, it's always a good thing to purchase gold because the value of gold never goes down. It can only go up. It can fluctuate at times, but mostly the value goes up. But I think one of the easiest and fastest ways that people use to build wealth is real estate. Because if you purchase real estate in 10 years from now, the value of it can only appreciate, especially if you understand how to work it, if you understand what you're doing, and you don't waste time doing anything, crazy, like in terms of failing to pay the mortgage or neglecting the taxes on the property or any of those things. You're more likely to grow your wealth aggressively with a piece of real estate. So if you and your family migrated from some country, one of the best ways is to pool your resources together as a family and purchase a piece of real estate. But also, the easiest way to avoid dispute over the property is by putting the property into a family trust. A family trust is an easy way to protect your asset because the trust actually tells every single person who owns what in the property. If you purchase a property and you put it in 4 different people's name, yeah, you could do that and say tenants in common. But as the parties dies, you're going to have to go and probate the person's estate to remove that portion out of the person's name and put it into somebody else's name. But if you put that property into a trust and then you transfer it into the names of the trustees, if a trustee die, automatically there's successor trustees that you can just change the deed without having to go through any probate or anything of that nature, which is going to cost you additional money to probate an estate and to switch the deed over. If you're going to switch a deed, it just costs you what, the attorney fees or the title company fees, along with the cost to register the new deed, which I think is much more effective than if you have to go through and you have to probate your estate. Not that I'm saying probating your estate is a bad thing, it's not, but it just is more costly. The less cost effective method would be a trust, because the trust now, it could pass from trustee to trustee. You can amend the trust at any time. Even if the settlor is gone, the trust could put powers into the trustee's hand so that the trustee could be able to amend the trust, so that the trust could continue in perpetuity. Of course, that wouldn't happen in Guyana. Guyana trust doesn't continue against the rule of perpetuity, but it can do that in the United States. The trust can continue. You can just amend, change trustee, but the settlers, whoever they were, even if they pass on, it wouldn't make a difference. But the most important thing is you'll ensure that your property is secure, it's protected. And if something happens to one of the trustees, it will just pass from one to the next and it wouldn't be a problem. But guys, I think it's really important that we have this conversation. You contact your attorney, discuss your options. It doesn't matter how little you think the asset is. It will help to protect the generation behind you and ensure that your family behind you doesn't have to work as hard as you did. So if you're the one that sacrificed yourself to ensure that your family get wealth, make sure you protect that wealth. Make sure you just don't leave it to chances and then you die intestate. Because I've had situations like that where people came to this country by themselves. They work hard, purchase property, have over almost $1 million in asset, and then they die suddenly. And then there's no will. No one can find a will. The person failed to create a will. So then now the issue is, how does the asset get divided? Fortunately, there's a rule of intestacy, but you don't always want your property to be distributed based on the rules of intestacy. There's times when you don't want certain persons to benefit under your estate. But if you just leave it to chance, trust me, your property is going to go to your family based on the rules of intestacy. And the rules of intestacy says that if a man or a woman die without leaving a will, if the person was married, then the spouse gets most of the estate, first $50,000 and then 50% of the value of the estate. Then the balance goes to the children in equal portion. If there's no children, then the spouse walks with all. And I've seen countless situations where people had, maybe they have like parents, right? Because this thing goes in an order of priority. If no children, then it goes to brothers, sisters. If no children, it goes to parent. If no parent, then it goes to brothers, sisters. And that's the order it keeps going down in. And there are instances where people, they have never gotten married, or maybe they married and the family never liked the spouse. You understand? And they just die suddenly. And the spouse that nobody ever liked ends up walking away with everything for that person. Or the spouse could literally sue the estate. Everybody knows that famous case with Anna Nicole, the famous porn star who retired. And she had married a very old, much older man. And she ended up inheriting from his estate. But the fact of the matter is, if you want to ensure that a niece or a nephew or some distant relative benefit from your estate, you got to make sure you create the will or put the property into trust to protect it. Do not leave your property exposed. Do not leave it to chance. It's really important that you take active steps. And then for those of you who have a relative that died and you're sitting on the property, you never probate the estate to change over the deed to your name. I would encourage you to go ahead and do it. Because I know situations where people had a relative that died, leave them in a house, because they were not the child of that relative. They just allowed the house to sit there in the deceased's name, and they're paying the taxes, they're upkeeping the home, and they're staying in it. I would encourage you to go and get the estate probated, right? Get up and go take care of that. Even if it costs you money, you have to do it. change the deed over to your own name, so that if you're putting your money into an asset, at least make sure it's in your name and it's not in somebody else's name. And I also know of instances where people buy assets in somebody else's name. I can't tell you the amount of situations I know like this, where somebody has money, but because of something, the credit might be bad or they might have some sort of issue, they cannot put the asset into their own name. So they go and they ask a friend, and they call the friend a family member or whatever, and they put the asset into the person's name. But the house or whatever that they purchase is, they're living in it, they're controlling the money and everything else from it. But that is the dumbest thing I've ever seen. People take their hard-earned money and purchase a house in a friend's name because they don't have the credit or whatever the situation is. Because you know what happened? If you die suddenly, guess what happens to that asset? That asset goes to that person whose name it's in. And then you have to go and fight with the estate to prove that it's your asset and not the deceased's asset. So in a case like that, I would definitely encourage a person, if you have money, you want to purchase an asset in somebody else's name, at least make sure there's a trust. Make sure there's some sort of agreement to protect your investment, right? I've also known about cases where family purchase asset in a family name, but their name is not on the deed because they didn't have good credit. And then they have to go to court to partition the land. Remember, guys, any agreement for land must be in writing to satisfy the statute of fraud. If it's not in writing, there's no valid agreement. So if you purchase a piece of land, real estate in somebody else's name, guess who owns it? The person whose name it appears in. And then you now have to establish that you have an equitable interest in that property. So to avoid these things happening to you, I encourage you guys, make sure you take the right steps. Make sure you have things in writing. Make sure you protect yourself, protect your family, and protect your assets for those who are behind you. Again, guys, if you have any question about today's edition or any of the series I've made here on Facebook Live, you can always give me a call. Call the office. The number is 718-877-3100 if you're in need of legal advice. Remember, consultation is free, no cost to you. It doesn't cost you anything to pick up the phone and call for legal advice. And if you believe that your situation might be more suitable to take immediate action, we're there to assist you. The office is located at 455 Utica Avenue in Brooklyn, New York. Again, I'm your host, Attorney at Law Shellon Washington, bringing you today's edition of The Law and You. Guys, I hope you have a great rest of your weekend. Enjoy the rest of your Saturday afternoon and your Sunday, and then it's back to work on Monday. If you got any questions, we're in office on Monday. You can give us a call then. Thank you so much for joining me, and I hope I'll see you again next Saturday for The Law and You. Thank you, guys. Enjoy.